Welcome. This is the meeting of the Wooddale Community Development Commission. My name is Sean Conway, and I'm the attorney for the Wooddale Community Development Commission. Ms. Bocheha, could you please call the roll?
Mr. Damasco?
Present.
Mr. Ochoa? He's not here. Mr. Pedersen? Mr. Peterson? Sorry, I'm sorry, Peterson. Mr. Shemanek?
Here.
Ms. Shatko?
Here.
Mr. Vand?
Here.
Mr. Woods?
Here.
Okay, the CDC has a quorum present. So we are still operating without a chairman. I believe, I think we're anticipating a chairman to be chosen
Hopefully by next week.
sometime in the near future. But until we do that, we have to do a motion to appoint, it's called a chairman pro tem. We've been doing this over the past couple meetings. I believe Mr. Shemanek has graciously volunteered to take on that role for his brief appearance. So what I'm asking for right now is just a motion to appoint Dave Shemanek as chairman pro tem. Do we have a motion?
I'll make that motion.
Okay, that's motion by Mr. Woods.
I'll second.
There's a second by Mr. Vant. And all in favor say yes.
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 Okay, all opposed say no. Okay, the motion carries. And Mr. Shemanek is our chairman pro tem for tonight. And Mr. Shemanek, do you have any requests of me?
You bet. Mr. Conway, as Chairman Pro Tem, I request that you serve as the meeting and public hearing facilitator tonight.
I certainly will.
Great.
Okay, so next on our agenda is the approval of the meeting minutes for the August 17th, 2020 meeting. I need a motion to approve those minutes.
I'll make motion to approve the minutes of September 2020.
It looks like it's the August 17th.
August 17th, I'm sorry.
That's okay.
I'll second that.
Okay. That was a motion by Ms. Satzko and second by Mr. Woods. Sorry, I'm just also taking some minutes here. Okay, all in favor say yes?
Yes.
All right, all opposed say no. All right, the motion carries and the meeting minutes of August 17th, 2020 are approved. Okay, so now we're headed to the meat of tonight's meeting, which is the commissioner training. We like to do this every time new commissioners are appointed. It's useful, obviously, for the new commissioners, but it's useful too for the commissioners that have been on for a while that just you may have some questions, based on the meetings that you've been attending, some nagging things that you've always wondered about. And tonight is that opportunity to ask any questions that you have of myself or of Gosha. On behalf of the City of Wooddale, I do want to thank all of you for your time and service on this commission. We realize that you're taking time away from your families, from your jobs. It's a very important role. You're making recommendations involving sometimes million-dollar properties in the city to the city council. So it's a very important role, and we really respect that you have taken on this obligation. And we know that you'll fulfill your roles to the best of your ability. We don't have any doubt about it. So with that said, tonight the way we're going to do it is Gosha is going to sort of go through some of the nuts and bolts of planning and of zoning. And then I'll follow Gosha, and I'll sort of go over some of the legal aspects of zoning that you'll encounter. So with that, I'm going to cede the floor to
Thank you very much.
Gosha.
Thank you. So as we go through this, if you guys have any questions, feel free to stop us, and we can always stop and address specific questions, or we can take some questions at the end as well. So I did want to begin with just a couple of quotes. You may have seen these before, but the first one is, if you fail to plan, you are essentially planning to fail. So this is one of the quotes, why is planning important, just something to think about. The other one is, if you don't know where you're going, how do you know that you've arrived? Once again, just something to think about, why we plan and why do we do the things the way we do. So elaborating a little bit more on the importance of planning. First of all, planning allows us to set directions and priority. And the key here is that it's supposed to unify the stakeholders. So planning allows us to take the community, the property owners, the business owners, the tenants of the particular businesses or residential tenants, but also the elected officials and the city staff. And planning allows us to sort of come together and figure out what are the goals and the priorities, what is the direction that we want the city to move forward to. Planning also simplifies decision-making. Having that end goal allows consistent decision-making. So the idea is that everyone sort of understands the process and kind of understands how we have to go through whatever the entitlement process may be. So it's a little bit easier to make that decision and be consistent about it. Planning drives alignment of resources. So this really comes in for budgeting purposes. It really, for infrastructure improvements or identifying potential properties for redevelopment. That's the whole idea of kind of looking at the available resources and what can we do with them and what direction we want to take it. And also planning communicates the message, once again, that unified stakeholders coming together. This is our vision for the city. This is where we would like to take it. And then if new, let's say, developers come in or somebody actually sees a property that has potential for redevelopment, it's clear to them what are the expectations and what we as a city are looking for. A little bit more on the planning framework. So there's actually a couple slides that cover this. So the very first thing we want to start with is the comprehensive plan. This is a very important document that every municipality has, and the comprehensive plan is a guide to the overall growth, the future growth and development. But in the case of City of Wooddale, where it's a mature community, there's not a lot of vacant space. A lot of it is really a redevelopment of existing properties that may have the potential for redevelopment. The comprehensive plan is really general because it touches upon many different aspects of the municipality and how it all comes together. In addition to the comprehensive plan, we could have neighborhood plans or more of a corridor plans. Those tend to be more area specific, where they focus on a particular area and what is the potential for that particular geographic area. Moving on with the planning framework, we also have the regulations. So this is our Chapter 17 and a few other chapters of our municipal code that are very specific in terms of technical specifications. Like in zoning, we've got the lot coverage, we've got the building height maximum, the zoning districts, the permitted uses. So those are more of the technical requirements. And we also have something called design guidelines. So this is more of an idea of maybe an appearance, like a particular neighborhood has a particular appearance to it, and we want to make sure we preserve it so we can apply design guidelines to that neighborhood. We don't really have a lot of that other than our overlay district. However, as you probably are aware, the city has hired a consultant who is looking at our zoning ordinance. As we speak, it's been going on for a few months, so hopefully we'll be able to bring something in front of you in a few short months or maybe less. And the consultant has sort of touched upon maybe using some of the design guidelines as part of our zoning ordinance. So we'll see how it evolves, but it's just another way how we can frame our planning efforts and kind of frame where we want the development, the direction that we want it to go into. So looking a little bit closer at the comprehensive plan, the first document that I mentioned. First of all, well, it is very comprehensive. It really focuses more on physical development of the municipality, but also looks at every geographic area of the community and ties together the infrastructure, the recreation, transportation, and housing, It really sets goals for the community for the next 10 years. But most municipalities tend to update it every 5 years or so as the market conditions change or something else happens with the economy. It's really good to take a look at the document every few years. Once again, we've got that alignment of resources, so we want to take the goals from the comprehensive plan and all the stakeholders that really come together and match them with policy, and this is really when budgeting comes in. And then the comprehensive plan is a policy document, it's a instrument, and it is subject to change and may be modified as outlined in our video. So we do have a specific section that talks about how the comprehensive plan may be modified. This is just a cover of our latest plan. It was approved in August of 2018, so it's a fairly new document. It is available on our website, but if anyone would like a hard copy, you can just let me know and I'll be happy to provide it to you. As you have probably recalled, a lot of the staff memos and the presentations that we do, we always touch upon the comprehensive plan and how the particular proposal fits within the comprehensive plan, but we also talk about compliance of that particular proposal with our zoning ordinance. So those are the two really big components.
Can I just say something, Gosha? So think of the comprehensive plan, if you want to make an analogy, it's like the Constitution. You know, you have the U.S. Constitution, then you have laws, right, that implement the Constitution. The comprehensive plan is like that. It's that broad document, and it doesn't have all the detail in it. It's just kind of, it's informing you, and it's informing the city council of what is the long-term goals for these various districts in Wooddale. So every time you get some sort of request for zoning relief, what you'll see in the staff memo, in the standards is, okay, is this in compliance with the overall vision of Wooddale? That's really what the comprehensive plan is. And I know most of you know that, I just thought it bears repeating, because it really is your long-term vision for the city. Sorry, Gosha.
Oh, no, thank you. Here we have a slide that looks a little bit more at the components of the comprehensive plan. We don't have to go through detail, but I did want to touch upon the fact it really starts with studying of the existing conditions, and then that public engagement summary comes in. So there were a number of open houses where everyone got together, and different work groups and workshops where people got to sort of develop what are the ideas and how we want to move forward. Really the big component of the comprehensive plan is that number 3, goals and objectives. It identifies a number of goals and then objectives, sort of how we can achieve those particular goals. Land use is a big component. We have a study of the existing land use and then the future land use. And usually in our memos, we look at that future land use map and see what was the direction for that particular parcel in the future. As we touched upon, the land use map really breaks down the city into sub-areas depending on the location and sort of the existing development. We've got the infrastructure parking component. There's a housing study in there. And ultimately, it's sort of like the implementation is the last point of what we can do to get started with achieving these particular goals. I did want to mention a comprehensive, a corridor or a neighborhood plan. We don't have anything that's recent, that's very specific. This is a plan from 2013, the Downtown Vision Plan. This plan, it has sort of many components to it, but really the idea was to create sort of a city core. And you may see we are north of the train tracks. The main street is Wooddale Road. And the idea is to create a gathering space with a garden, pavilion, possible relocation of the barn from the Historical Society parcel. And this would be a sort of like a space for a park and future festivals. And so obviously this is something that is ongoing. Some of the components like relocation of Commercial Drive have been completed, so some of the infrastructure items, but obviously this is something that's still in our future, and hopefully we'll be able to complete these components in the future. But I just wanted to show this as an example of a neighborhood plan because it really focuses just on that particular area. A little bit more on the regulating development, so the actual document itself. This is just an outline of the different chapters of our municipal code. Chapter 17 is the one that we always mention, the Unified Development Ordinance, or UDO as we call it for short. This particular chapter contains our zoning requirements, so a lot of the parking requirements, lot standards, accessory structures, and so on. We also have the subdivision section for anyone who wanted to, let's say, subdivide parcels or consolidate parcels. We have our stormwater requirements that are now in Chapter 10. They used to be in Chapter 17, but we did have a text amendment, I want to say a couple months ago, where a separate designated chapter was dedicated to stormwater requirements. A lot of our engineering numbers and specifications in terms of detention are in Chapter 10. Chapter 13, I did want to mention sign code. This is also something that falls under the CDC Commission purview in terms of sign code variation requests. And we also have building code, which is Chapter 12. This is something that really guides development, but typically that is not a request that would come in front of the CDC Commission. But this is, in general, the different chapters of our municipal code that really regulate development. I did want to speak just a little bit about the process of really what happens prior to the application being presented before the CDC Commission. What we really like to do, which has been a little bit tricky lately because with limitations on in-person meetings, and but we've actually had a couple phone conferences and we were able to meet with a few applicants. What we like to do as staff is actually hold a pre-application meeting with anyone seeking any type of relief, whether it's zoning relief or any type of process. This really allows us to sit down with them and figure out what is that they're trying to achieve and whether any relief would be required and really how to get there, because sometimes there could be different avenues or different requests that they can really go for. So at the pre-application meeting, we sit down with the applicant, we give them all the requirements in terms of what documents need to be submitted, how the process really works, and then they go out and work with their contractors or architects, depending on the size of the project that they're doing, or maybe this is something they're doing on their own. They put the documents together and resubmit to us. That takes us to the next step, which is the submittal and review of the application. This is where we as staff do our review. So there's always that zoning component, which we do in-house. Sometimes we have engineering. So we do have engineering in terms of stormwater management. We have sometimes traffic impact studies. Some projects require a public works review in terms of infrastructure and utilities. So there could be different components. In some cases, even building code does get a little bit of a review. Once again, depending on the type of project, if this is a brand new development, let's say multifamily that's being used, then obviously we want all of our reviewers kind of present, even at this point, where we're not even at permitting phase. This is just very initial, just to make sure that we're on the right page. As an opposite example, we recently had a rezoning of a residential property. Obviously, that one is not going to require as much review because it's an existing condition. They're not really changing any of the physical. So it really depends on the type of application. So after our review is completed, we as staff put together a staff memo. So that is sort of a key document where we list all of the required standards of approval for that particular petition. So if it's a special use, we're going to use all the standards for approval for special use, and we provide the responses and whether the application meets that standard or not. What's really the key here is that we provide recommendation, a staff recommendation, really on the strict letter of the code. That's really our interpretation of what the code says, and those are sort of the perimeters. It is up to the CDC Commission to, during the public hearing, to listen to staff recommendation, to listen to the applicant and consider all the facts to see if you agree with that recommendation and whether any changes or conditions should be made. So we do provide a draft recommendation in our memos just to make it a little bit easier, but obviously it's up to the CDC to see if you agree with it and whether you want to change any of the standards or modify anything. The key here is that the CDC motion that moves from CDC to the City Council eventually should address the facts, the findings of fact related to the standards of approval. So that's sort of kind of importance of how everything ties in together. After the public hearing, the petition always moves to our Planning, Zoning, and Building Committee, PZB for short. That's where it's first being considered before it moves to the next meeting, which is the full city council, which usually makes the finding recommendation. So CDC is a recommending body, and you either recommend approval or you recommend denial of that particular petition. And then, I guess I touched upon, so the very last item for approval in this case would be the city council. And with that, I will move it forward to Sean.
Okay. Before I get into my piece, hi Jimmy, just to kind of give you a review of what Gosha just went over. Gosha was just going over some of the planning aspects that city staff does. She talked about what's called the comprehensive plan, which is a larger sort of what I'll call a vision document that kind of lays out the vision for the city in terms of its future planning. And our city code is sort of the nuts and bolts, those are the actual regulations. So right now, Gosha was just going over the comprehensive plan. So that's kind of where we're at. And before I move on, does anybody have any questions for Gosha about anything that she's gone over, or just general questions about procedure?
The PCB recommendation, do we get that the day of, or do we get that in an email before, or is it normally presented like last time?
Yeah, so what happens just procedurally is an application will come in for zoning relief, and I'll go over some of the different types of zoning relief. That'll come in, staff will review that application. Sometimes staff may say to the applicant, listen, you're missing, a bunch of pieces here. Here's what you need to have a complete application. They may return it. Eventually, once the application is complete, they'll set the matter for what's called a public hearing. And that's a public hearing before this body. This body will have the public hearing, all the evidence will come in, you'll deliberate, you'll make a recommendation to the city council. And then it goes to, before it gets to the city council, it goes to what's called the PZB, which is basically a committee of the whole for the city council. The PZB committee will vote, it will make its recommendation, and then it'll go to the full city council. So the PZB, I hesitate to even call it a hearing, the PZB consideration comes after this board has made a recommendation. Does that answer your question, Kamal, just in terms of process?
And if I may
Yeah.
add, so the recommendation that I was talking about, it typically is part of the CDC staff memo. So usually, we publish the agenda, it gets posted on our website, and that's where I try to let everyone know, hey, we're having a meeting on this and this date. And then, we really try to have it about a week before the meeting. It really depends. In a lot of cases, I can't release the packets because I'm waiting on like a piece of document or something from the applicant. So once we are able to complete the packets, I let you know that they're always posted on the website. And the packets usually consist of what you have, so it'll be the agenda, the minutes from the prior meeting, and then all the staff memos with the attachments from the applicant. So the staff memo is really the document that outlines the project, it provides an overview. It lists all of the standards for approval that are required for that particular petition, and it has that draft motion following staff's recommendation.
And just to follow up on Gosha's comments about the staff memo, we represent a bunch of communities, and they're all very good and different in their own way. I have to say, the way Gosha prepares the staff memos is exemplary. It is really well done. Gosha does a very nice job going through the standards for each request for relief. And I find them to be very clear. I'm not often confused by the memos. I think they're just great. So I would encourage you, it's a great resource for you to review before the actual hearings. And like Gosha said, there'll be a recommended motion on the relief in there, and those are always really well written. So I just strongly encourage you to to review those memos, so they're really good. Okay, any other questions for, go, yeah,
I have one that I'm not clear on.
okay.
We did a case probably 2 years ago for you know where, the bar on Irving Park, to allow them to insulate the walls. Came to us. I understood why it came to us. We voted on it. And then we asked ahead of time that they were not going to get windows, and were told that they weren't going to get windows. Now, they come back to get windows, and it didn't even come to us. I'm just not understanding why would you come to us with the walls and not the windows?
Yeah.
I mean, they
Well,
were both the same variances.
Yeah, I don't want to talk about specific cases.
Well, you asked
but
me if I understood, and I don't understand.
Yeah, so here's the process with that. I believe you're referring to a special use that was granted at some point
Correct.
in time. So, and it's actually an excellent question. So a special use, this body can grant. It's actually a use that's allowed in the code. It just needs city approval. It needs a city permit. So when that use comes before this board, sometimes there are conditions that are recommended on that special use. So there's the actual special use that's approved, but then there may be conditions. Okay, yes, we'll give you the special use, but you need to do A, B, and C, whatever that is. That could go up to the city council. The city council could accept those conditions. They could come up with their own conditions. And so when the city council eventually votes, they vote on the special use, but also the various conditions. So I wasn't involved in this one, Dave, but what I believe happened was that this applicant must have been asking for a change in one of the conditions. And if that's the case, the city council has the authority to change that condition without it coming back here. It can be modified, that condition can be modified directly by the city council. So they need to go back to the city council to ask for, some change in that condition.
Is that what they did, ask for a change in condition?
I honestly, I'm not quite sure. I don't know exactly how the approval was granted, so I'm not quite sure.
I just found it really unusual. You come to us with part of it and then don't come to us with the other part. It kind of leads me astray of what we're actually doing.
Yeah. Yeah, go ahead, Dave.
If there's a condition on a situation, or if there's not a condition on a situation, does that mean that it's wide open?
Yeah, so let's say, for example, the applicant comes in, they want to do a church in residential. That's typically a special use in most codes that I've seen. And you can recommend approval of that special use without any conditions whatsoever. And then they just have to follow the code, whatever the code says on various, the various regular parking or whatever it is. Goes up to city council says, yeah, we agree that we'll approve the special use. They don't have to put a condition on there. But if they do, the condition has to be followed. If they don't, then it's just the code. They have to follow the code. Does that?
Yeah, it does, but for some reason, I'm thinking even a little bit further now, and I'm thinking like planned unit developments and things like that. And then there's conditions within those that have an association, and then the city is required to make the people within those association follow, or according to the code, for example, if the association doesn't allow fences, the city shouldn't allow a permit for a fence, correct?
Yeah, so now what we're talking about is what's called a PUD.
Right.
For the new folks, that is what's called a planned unit development. It's at the end of the day, a planned unit development is a type of special use. So in our code, it'll say in the various districts, you can have as a special use a planned unit development. Illinois law has created planned unit developments for very unique, usually larger developments, where the developer will need some variations, they'll need some relief that wouldn't be typically allowed in the code. So it comes all in one package as what's called a planned unit development. But it's the same concept. It can be approved, or this board can recommend approval with conditions, just like a regular special use. The city council can accept that. It can say, no, we don't like condition 2, 3, and 4. We like condition 1. They can come up with their own conditions. Once that ordinance is passed, that PUD or special use permit ordinance, that's where you look to find the conditions that were imposed. And those must be followed, because if they're not followed, then it's a violation of the special use permit. So, anytime a condition's imposed, it has to be followed.
So who's accountable for following those conditions? Is it the approval process of the city? So for example, if I have a house that's in a planned unit development, that planned unit development concludes all houses around me. And for example, maybe a fence isn't allowed in the planned unit development. But the city approves a fence and it goes up. They approve a few others. What recourse is there or isn't there?
Well, the fence, if it's in the ordinance, it says no fence, then the city has to enforce that. If there was a fence that was approved, by mistake, unfortunately, I've worked with many communities, that has happened in the past. That, however, doesn't excuse complying with the special use permit ordinance. So if the fence went up in error or a permit was approved in error, the city is within its legal right to say, listen, we made an error here and you cannot have that fence. That's not allowed in the special use permit.
Wow. With no recourse for the homeowner or builder? Or?
Well, I can tell you, those matters wind up in litigation.
Yep.
Anytime. Right. So, now I'll say this for your purpose, you're making recommendations to the city council. You don't really get involved in the enforcement piece. That should be the community development department and their code inspectors. So you don't have to worry about, you don't have to go out looking for violations. That's not what the city's asking you to do. What they're really asking you to do is make recommendations on those applications for zoning relief when they come in.
Correct, but on the same hand, we've got to try to understand why they do things they do
Yeah, absolutely.
when we might sit and see and know they're not right. So, okay.
Any other questions? These are great questions, by the way. Any others?
So does the city have a list of what is a planned unit development and what isn't?
What do you mean, like when do they have to apply as a plan unit development?
No, what within the city is.
Oh, absolutely, yeah. Every plan unit development is memorialized by an ordinance.
So then realistically, whether it's a planned unit development that has some type of association, they should have all the accompanying rules in order to figure out what they're looking at. They should have everything in theory.
Yeah, now what I will tell you is, the city doesn't typically enforce bylaws of, let's say, a homeowner association. That's not part of the plan unit development approval, typically. So that's not something the city would be out enforcing. That would be basically a civil matter between the homeowners.
But if the bylaw has that you can and cannot do something in there which requires a permit from the city, would they be required to follow that and understand it and know it?
Yeah, that's more getting into a civil matter.
Really?
It has, yeah, the condition has to be in the ordinance itself, not in a bylaw.
So bylaws are kind of like guidelines, not rules.
They're rules amongst the homeowners, right? So if a homeowner in a homeowner association is violating a bylaw, typically their recourse is civil, meaning they'd have to sue one another. Anything else before I move on? These are great, I love these questions, by the way. Okay, so I'm just gonna kind of go over some of the nuts and bolts again as I go through. If you have questions, stop me, we'll cover them for you. Obviously, you're the Community Development Commission. You're the recommending body to the City Council. In my experience in the city here and most of my other communities, they take your recommendations very seriously. Many of the times, your recommendations are followed. Sometimes they are not. That's okay. I mean, that's how the system is designed. City Council does not have to accept the recommendation, but in my experience, many times they do. Because you're the ones listening to the testimony, looking at the documents, examining the evidence, and determining whether there's basis for the zoning relief. City Council, obviously, they have the final say in granting the zoning relief or not. I am your city attorney. We have two other attorneys in our firm, Mary Dixon, Pat Bond. Sometimes either one of them may come and assist you at a meeting, depending on if one of us has a conflict. But our job is to provide you legal advice, during your meetings or outside of your meetings if you have a question about the law. That's our job. We do not make recommendations on policy. We're not going to say, hey, I think this is a great request for relief. I think you should go for it. Or vice versa. We're not going to say, oh, this is bad. Don't do it. We don't get into the policy. We are advising you of the law. What does the law require? That's our job. We also do that for the city council once it gets up to the city council level. Yeah, go ahead, Jordan.
I've attended my share of city council meetings, years worth of them. But the whole thing starts with the building department. They're the ones that have the boots on the ground. They're the ones that do the investigating. They're the ones that do the processing. Every time I get something for approval, I always go to your recommendations. Now, I have seen a change in the building department over the last 10 years. And to me, it's gotten nothing but better. You guys do your homework. Sure, we look at the people, we watch their eyes, we ask questions, but you're the ones that have the nuts and bolts. You're the people that, we look at your recommendation. Now, in past administrations, or however you want to call it, I didn't follow that. Because in my opinion, it was either black or white. There was no understanding. There was no gray area. This is it. It's my way or the highway. And I think in this administration, if I may use that word, I think there is more compassion. You look at both sides of the coin. You're where it starts. I come into this meeting, I look at, is it good for the betterment of Wooddale? That's what I look at. I've been in this community now for 42 years. And, geez, wish I could make another 42, but I don't think that's going to happen. But, the thing is that you're the eyes and ears of this. There's certain things that I listen to. The reason why I ask the questions I ask, because I foresee problems. And then you take them where you want. If it's a parking issue, if it's any type of issue, I look at that. That's all I got. Thank you.
Anyone else? Well, your comments, George, dovetail nicely into my next slide, because I was going to be talking about staff. You're absolutely correct. The staff, in my experience here, they did an excellent job looking at these applications. They match up the request for relief with the standards that are in our city code. In the memo, it says, here's where they followed standard 1, here's where they didn't follow standard 2, and they go through, and it's very nicely done. They put a lot of thought and effort into it. Staff, unlike your legal counsel, staff will make recommendations. They will say, listen, I think this meets the standards for relief. Or they'll say, listen, I don't think it meets all the standards for relief. So they will do that. They'll make that initial recommendation to you. And you know, feel free during the public hearings to say, okay, I see standard 3, you said no. Can you elaborate on that a little bit? Why not? Why don't you think? And that's what staff's here for. They do a great job at it.
Yep.
Okay, I want to talk to you a little bit about the different types of relief that folks will come in and ask for. There's really 3 main types. There's what's called a special use. There are amendments, and within amendments, that kind of includes what are called rezonings, or amending the code to get yourself into a different zoning district. And then the third main request for relief is called variations. This is just, I'll just put this out there. If you were to guess which one of these requests are more difficult to achieve under the law, does anybody have a thought about which one of the 3 is the most difficult?
Variations.
Variations, that's exactly right.
Yeah.
That's exactly right. And I'll tell you why. A variation, when somebody comes in, they want a variation. What they're saying is, your code doesn't allow it, and I want you to make an exception for me. Just on a case-by-case basis, an exception. It's under the standards, it's really difficult to get a variation, and you would expect it so, because it's not allowed in the code. So they really have to come in the standard you're really looking at is that what's called the hardship standard. Has something happened to this property, or the classic hardship scenario is IDOT comes in, takes some of the property, and now they can't meet a setback for a shed or something like that. It was something completely out of their control. IDOT caused the situation. They're saying, listen, I want to do the shed. I would have been fine had IDOT not come through and taken some of my property. There is a classic hardship that it was out of their control. They're just asking for an exception because of that unique circumstance. So you're right, Chief. It is variations, the most difficult one to get. Which one do you think is number 2 on the difficulty scale? Now you got special use and amendments.
What was the third one?
Variations, we just
Yeah.
determined that's the most difficult one to get.
Okay.
So you got special use and amendments.
Amendments.
Well, let me do this. Let me kind of go over both of those
Okay.
types of relief. When somebody's asking for a special use, it's actually a use that is allowed in your code. The code says, yes, you can do a church in the residential district, but you have to get a permit from the city to do it. And usually zoning codes attach special uses to certain uses that may have an impact on the surrounding area. So like a church in a residential area, well, there's probably going to be some traffic impact that's going to happen there. So the city wants to have some some foresight about, okay, how are you gonna impact traffic here before we give you the permit? So it's usually uses that have a little bit more impact on the surrounding properties, but the city's determined, hey, as long as you satisfy the standards, you can do it. You just need a permit. An amendment is asking the city council to change the code. Is, whatever it may be, you can, in all residential districts, you can have a fence up to 6 feet tall. Well, now you want a change in the code that's gonna impact all the properties in that district, saying the maximum height is 8 feet now. So knowing those two types of relief, which one do you think is more difficult to get? Amendment. Absolutely. So special use is actually the easiest one to get, simply because the city council has already said, yeah, that's fine, that use is fine, we just want to know about it, we want to control that situation. So those are really the three main types. I have on there rezoning. A rezoning is if your property is I-1, it's in the I-1 district on our zoning map, and now you are real close to I-2, and you want to be I-2 now because you can do more things with your property, let's say, or whatever the use is, it's allowed in I-2 but not in I-1. So you may come with an application saying, I want to be I-2 as opposed to I-1. It's just a fancy way to say, I want you to amend your code, because you're making what's called a map amendment. You're changing the classification for that particular property. You also review subdivisions and consolidations. That's less common. It's really the special uses, the variations, and the amendments. And like I talked about a little bit earlier, a PUD, or a planned unit development, is just a complex special use. It is a special use at the end of the day. Okay, so, this slide is just talking about your powers and duties. You'll be looking at, from time to time, making amendments or making recommendations on amendments to the comprehensive plan. Remember, that comprehensive plan is that larger, vision document that may come before you every once in a while. There may be some zoning relief that folks want prior to annexing into the city that you will have to consider. And then there's matters that the city council can just refer to you for your consideration and recommendation, and that's in our zoning code. Okay, I think you wanted to should go
Yep.
over this example.
Yeah,
perspective.
I wanted to provide a couple of the examples of obviously, most of you may recall these projects that have come across CDC probably in the last 2 years, but this is just one of the examples as special use. We had an applicant come in for a Allstate insurance agency. This is a property along Irving Park Road, right near the intersection of Wooddale Road, and this was like a classic case of a special use. It's a permitted use, but requires the additional approval. It was presented before the the CDC Commission. Last year, it was recommended for approval, and City Council did approve them, and they're all moved into that particular area. So this was just an example of a special use that we have seen. The next example we have would be a text amendment. This was actually a staff-recommended text amendment. We wanted to clarify the fence regulations. I believe that was towards the end of last year. We amended a few sections specifically related to backyard fencing for corner lots. Once again, wanted to clarify for the residents and also for ourselves. we added this diagram, and we clarified some cross-references that were in our code. We are referencing different sections of the code and maybe repeating ourselves a lot, so this was just a change to the actual text of the municipal code, and that is also something that typically comes before the CDC commission.
I just
from
wanna,
Service 17.
I'm sorry.
Oh, no, go ahead. Go ahead.
I just wanted to piggyback on that. A lot of times, what staff will notice after they are going through the code and they've had, you know, various requests for relief, they'll look at the code, and, because our zoning code is very complex. I'm just gonna tell you that right now. In fact, I think they're looking at an overhaul of our
Yes,
zoning code.
we are working on it.
You know, the problem is, the more complex your zoning code is, the more likely you may have an inconsistency, things that don't quite match up. And as staff is going through and doing their job, they may notice an inconsistency that needs to be cleared up. And so staff will actually initiate a text amendment so that there's clarity in the code. There's no confusion about what the requirement is. So, you know, that happens quite often. Hopefully, once they adopt a new code, that'll happen less, but, you know, it does happen.
Coming shortly. This is another example, very recent. We just talked about it at our last meeting. This was a rezoning request. So we do have a residential property that would like to annex to the city of Wooddale. Annexation itself is something that can go directly to the city council for approval, depending on the type of annexation. If it's a voluntary annexation, there's no annexation agreement. It just goes directly to city council at a regular meeting. In some cases, a public hearing may be required, but that also happens before the city council. However, as part of this annexation, we had a zoning request, and the zoning request was for rezoning. When the petition was being, or will be brought into the city of Wooddale, we wanted to make sure that it matches the surrounding zoning district. So the petitioner came in for a request for rezoning, which was presented before CDC, and was recommended for approval, and it has gone through PZB process, and I believe October 1st is when it's due to go in front of the city council, where at that point it will be a combined request for annexation, and upon annexation, it will be rezoned to the R4 that was requested. So this is just one of the examples. And a couple more examples. This one, and there's a couple photos, so you may have to hit once. So this is an example that actually had a lot of requests in it. This is for our 800 North Route 83. We had rezoning upon annexation, so this was new property. We had a special use for planned unit development. We had a subdivision and a major site plan review, which typically is part of any sort of a special use request. So what we have in front of us, this was a plat of subdivision. We had 30 residential properties that were consolidated into one large property. So this was the subdivision. If you click one more time, this was sort of the proposed one lot, one large building. So this was part of the planned unit development. And there's one more photo that will show you this is the renderings of the proposed building. It is currently under construction. The building is already standing up. Obviously, they're moving pretty fast on it. So hopefully by the end of the year, I think they want to be completed. So this is just an example of a more complex planned unit development where we have the rezoning, we've got the annexation, we've got the special use and the subdivision. So a lot of moving parts. And
Yeah, so, you know, what's interesting about this one is I'm looking at it, there's multiple requests for relief here, right? We have the rezoning, special use, which is the planned unit development. Within that planned unit development request, and I don't know if this was the case, Coach, maybe you can tell us, sometimes they request variations
yes.
within that. That's all approved as one thing. You don't have to approve each variation there. And then they're subdividing, and there's a site plan review, so there's quite a bit going on with this one.
And one thing I would like to clarify, I'm sorry, and sometimes you'll see it in our memos. Technically speaking, a variation request is just a relief request from the zoning ordinance. Once it is part of a planned unit development of PUD, we refer to them as deviations. So that's one way to distinguish. If you see us referring to something as a deviation, that automatically means that it's part of a planned unit development, as opposed to a variation, which could be a standalone request. And I think the last example, we have a sign code variation. So this one's a little bit different because it's not part of our zoning ordinance, which is chapter 17. This is our sign code, and we did have a request earlier this year. This was for a sign on the south elevation. Our code does not allow wall signs on elevations that are not facing the street. But this one is a little bit unusual because there's really vacant land to the south, but they don't have direct street frontage. So they applied for a request and were recommended for approval, and the city council did approve this request. So this is, I just wanted to kind of give you some visual examples of the different petitions that we've had in front of us in the last few years.
Okay, this slide is just talking about the standard for making an amendment. And as you'll note here, the standard is the amendment reasonable and does it bear a rational relationship to public health, safety, morals, or welfare? I'm going to give you the layman's version of that. As long as the city feels like it's in the best interest of the residents, the standard is met. I'll call it a lower standard for relief because it's really about policy. It's about, is this good for the city? Is it good for residents? It's the city's own code. So, if there's an amendment, they can say, hey, this is our code. We think our change is good for the city. It's good for the residents. So it's a lower standard. And whenever the city makes a change to its code and somebody, let's say, challenges that in litigation, it's the most difficult case to win as a challenger because it's very hard to prove that, oh, the city didn't think this was in its best interests. It's next to impossible to prove that. For the special use and for the variations, there's this list of standards that are in our code. What I'll tell you for your use is, in that staff memo, Gosha is going to go through each of these standards, and she's going to tell you, in her opinion, whether they've been met or they have not been met. The same thing is true for the variations. I bolded that second standard. It says, have you demonstrated an unusual hardship? Remember, that's what I was talking about before when you're looking at variations. Has the applicant come before you and said, listen, if I don't get this variation, I'm going to have a considerable hardship. And by the way, this wasn't a situation of my own making. That's really kind of what you're looking at there. Okay, so I just want to go over our general meeting and hearing procedure. And I think I said this at the last meeting when we were going through it. There's really two components. You have the public hearing component, and then you have the public meeting component of the same case. Okay, so you'll get a case, you'll start with the public hearing. The public hearing is the applicant's chance to put on their case for you, for your consideration. They'll testify, usually the applicant will testify. If they have an attorney, the attorney will make some remarks. Sometimes they bring in positive witnesses for their case. Maybe it's a surrounding neighbor that says, hey, I don't have any problem with the request that they have. They'll give you documents, they'll give you plans, they'll give you all those sorts of things. And at the end of the day, it's their job to prove their case. They have what's called the burden of proof. In that public hearing, you had the opportunity to ask the applicant questions any of the witnesses that testify under oath. You can ask them questions. You can ask staff questions. That is really your time to ask questions. It's not really the time to talk about your view of the case. Not yet. Not yet. You're really right then and there, you're probing. You're trying to get answers to the questions that you have after looking at the staff memo. So that's what the public hearing is all about. The public hearing eventually will be closed. Typically, the chairman will close the public hearing. And at that point, there's no longer can you ask questions. I really want to stress, if you have questions, make sure you get them in the public hearing piece. Because once that public hearing is closed, it's the time for questions is over, and now starts the time where you deliberate. So typically what will happen is there'll be a motion. Well, sometimes in the past you just start your deliberations. There's no, hard and fast rule. Past chairmen have just liked to launch into deliberation, and that's fine. That's where you make comments. You can make comments to the applicant. You can make comments to one another. You can ask each other questions. That's your time to really talk about, are you in favor of it? Are you not in favor of it? And things of that nature. So once you've done all of your deliberations,
Is there some kind of time limit?
No, there's no time limit. Now, I'll say most of the matters that come before you are not going to be that complex. You usually can get through a couple cases a night. Sometimes you'll have a pretty big case, and that could take multiple hearing dates. We've been involved in situations where it's gone, 5 or 6 times, back before you. And sometimes, although I can't remember any one recent year, I think maybe it's for our other clients, sometimes you have to get a bigger room.
We did that last year,
Did we have that one last year?
about exactly a year ago.
Yeah, because what the Open Meetings Act says is you have to have a big enough room for everybody who wants to participate in that hearing. So you could get a lot of resident interest, and if this room would just be too small, so you'd have to, usually in those situations, you have to reschedule and get a bigger venue. So I hope that answers your question.
So there shouldn't be any kind of pressure here to get a deliberation. If we feel that there's a continuance, we'll make a motion or something like that?
Yeah, sometimes you'll have a situation where the applicant will come in and maybe they realize they have an issue with their request for relief that they want to work on before they go to hearing. So they may come in and say, hey, can we continue this? We want to fix this issue before it gets to, full hearing. And in that case, I've always recommend, it's their case. We don't want due process issues. I just say in those situations, if they want to fix something, let them fix something, and so that they can put on their full case for you. So yeah, there's no time limit. There's in the zoning code, there's no time limit for your hearing. Now, I will say this. The chairman's role or the meeting facilitator, however we go forward doing it, the testimony still has to be relevant to the case. So, for example, if you had somebody get up and testify, let's say it's a special use for a church, again, I'll use that example. They get up and all they want to talk about is how cruddy the park district has been over the past 3 years. That's not relevant to the proceeding, and the chairman or the meeting facilitator would be within their right to say, sir or ma'am, that's not relevant. Do you have any questions pertinent or testimony pertinent to this proceeding? And move on. It's not open-ended. It's still, the participation has to be relevant to what's before you.
Sure. Okay, so once we close from the audience and we're discussing between ourselves, there should be nobody bring back in from the audience, correct?
That's right, right. So once that.
By anyone up here.
That's right. So, once that
Okay.
meeting is closed, you should not, as a matter of procedure, proceed to ask more questions of the applicant.
Or let somebody speak
Right,
out there,
yeah,
okay?
absolutely, yeah, because the public hearing, that's their chance to say their piece.
Got it?
Okay. Okay, this slide is just letting you know that, in Illinois law and under our code, public hearings are required for these types of zoning relief. The amendments, the special use, the variations, and the rezoning. This is just talking a little bit about how we do our motion practice. We follow what's called the Roberts Rules. We really only have a few types of motions that we make here. Just to go over the motion procedure, when you make a motion, that does not mean you're in favor of whatever you're moving. Okay? It does not mean you're in favor. You're expressing no opinion. You're just making the motion, getting a second, so that then there can be discussion. Your view on that motion is going to be your vote. So you could make a motion that you disagree with. There's a second, and then vote against it. That procedure is just to get it on the floor for discussion. It doesn't, if you second a motion, doesn't mean you're in favor of it. If you make the motion, doesn't mean you're in favor of it. It's just you're getting it on the floor for discussion.
Yeah, if it doesn't get seconded, it doesn't get on the floor for discussion.
That's correct. So common motions, motion to recommend approval, and I want to talk about that a little bit. The way our zoning code is set up, and this is very common with the other communities that I've represented, you want to make the motion in the affirmative for the zoning code. So let me give you an example. Let's go back to the church special use. I move to recommend approval of the applicant's request for special use for a church. We always make the motion in the positive, because that, for certain requests for relief, we need to have a certain number of votes. If you make that motion in the positive, again, doesn't mean you are in support of it. It's just that's the motion that's on the floor. There's a second discussion, and now you can vote whatever way you want. So there are some requests, like specifically amendments and variations, that require a positive vote of 4 members of this entire board. Special uses are different. They just need a majority. But the other two needs 4 members. So if they don't get 4 members, they don't get a positive recommendation from this board. That becomes an issue when, let's say, we only have 4 members present that night, and they want a variation, or they want an amendment. You're really rolling the dice, because you need all 4 people to say yeah. All it takes in that situation is 1 to say no. So we always make the motions in the affirmative. In other words, we never do, I make a motion to deny the request for special use, because it screws up the vote count.
But if the building department's recommending denial, it still doesn't go up that way?
So if the staff is recommending denial, still make it in the affirmative, the motion to recommend special use. You know what staff has recommended.
Okay.
If you agree with staff's recommendation, you vote no. You vote no. And I'll, as we get one that's kind of tricky like that, where you, and sometimes it happens, you have a staff saying, I don't recommend, I'll remind you that, just so you know, the staff has not recommended. We make the motions in the affirmative. If you agree with staff, you would vote no. If you don't agree with staff, you would vote yes.
Okay.
Okay. These are just other helpful tips. It's things that, in my experience, it sometimes happens. One of the things is called ex parte contacts. Here's what that means. You have an applicant, the case is before you, it's on, when do we do, Mondays, it's midday Monday. The applicant calls you up, Dave, please, you gotta vote yes for this, okay? That's what's called an ex parte contact, where they have, out of the hearing procedure, contacted you. So, what happens when that happens? That doesn't mean you're disqualified in any way. What my advice to you is to tell that person, I cannot talk to you about your request for leave outside of the hearing procedure. You then would disclose to me or to Gosha, listen, this person called me, and then we would just put it on the record. We would just say, we had a contact, didn't have any discussion, but just so you know, had that contact. It doesn't mean you're disqualified, okay? But just be aware, people will, it's just human nature. They may want to, they don't even know, maybe they're not supposed to do that. You just remind people, I can't talk to you about your request. I can only listen to the evidence and testimony in the hearing. Think of it as like judges. Judges are not supposed to talk to the parties or the attorneys privately, separately. All the communications are supposed to happen at the same time. You're like judges, basically. So just keep that in mind. Folks that have pending applications are contacting you, just politely say, listen, I appreciate, that you want to talk, but I can't, I'm sorry. But feel free to raise any of your points at the hearing.
Sean,
Yeah.
just visualizing that, at what point do you stop them? Hey Sean, I'm calling you about that variation.
Yeah.
Do you stop
I
them
would
right
say
there, or do you?
as soon as you possibly can.
As soon as you
As
possibly.
possibly can. Say, I can't, it's, and you can blame it on me. You say, the attorney has said, we can't talk to applicants outside of the hearing process. But please, I encourage you to raise any and all points that you may have at the hearing. Anybody else? Okay. Next point is the conflict of interest. Here's the classic conflict of interest. You have you own a gas station, okay? And that's fine, you can own a gas station in the city, and you want some zoning relief for whatever, for a higher fence or something like that, and you're the applicant. Obviously, you cannot be the applicant for zoning relief and sit on this board at the same time. That's a classic, what's called conflict of interest. In that situation, you would have to, what's called recuse yourself. And there's a process for that. If you find yourself in that position where you're the applicant and also on the board, I'll walk you through how you recuse yourself. But it's simply, you just let folks know that you're recusing yourself. You don't have to let them know why. You just say, I'm recusing myself. You would walk down from the dais. You can sit in the audience. I actually recommend you sitting in the hallway. And for that particular case, you're just not on the board. There's other areas of conflict of interest where it starts to get into what's called gray areas. For example, your best friend is requesting the relief. You have a very close relationship with that person. You don't know, should I be, hearing their request? Should I not be hearing their request? I'll say there's a lot of instances where it's going to be on a case-by-case basis. If you feel like you have a conflict that way, just let Gosha and I know, we'll work through it with you. You know, the safest course is you recuse yourself. You know, you just recuse yourself. You know, don't know why, you just say, hey, I don't feel comfortable, you know, being a part of this particular case. And that's it. Okay? Impartiality, what that means is you come into every case with an open mind. You know, you're not out making comments outside of this room saying, this is the worst thing ever. You keep an open mind. You can say this is the worst thing ever, say it in here, in the deliberations. Don't say it outside of this room, okay? You want to keep an open mind, because, listen, they may put on a case, when you first saw the staff memo, you're like, forget it, no way. They put on a case, they knock it out of the park, and you're like, well, actually, you know what, maybe this does warrant relief. So keep an open mind, listen to all the evidence as it comes in. Okay, Open Meetings Act, this board is governed by the Open Meetings Act. What that is every meeting we have is open to the public. Public can come in, we post an agenda, we have notice requirements. The big thing for you to remember is the Open Meetings Act has sort of a confusing definition of meeting. And it's one that people misunderstand very frequently. So, to have a meeting, we need 4 members. That's what's called a quorum. We have 7 total members. So we need a majority of a quorum. We need a quorum to have a meeting, okay? The Open Meetings Act says you are violating the Open Meetings Act if you talk about that case with a majority of a quorum. In this case, it would be 3. So if 3 members outside of this room were to talk about the case, that would be a violation of the Open Meetings Act. Even though it's not a quorum, it's a majority of a quorum.
We can still have coffee, we just can't talk.
You can have coffee, you can talk about the Cubs, you can talk about the Bears, you can know whatever you want to talk about. Just public business. You cannot, in particular, the public business that you guys, if you want to talk about, why are these stop signs all faded? Well, that's different. You're not talking about a pending case. You're still residents of the city after all. So you can talk about general city stuff, but when it comes to CDC matters and zoning, have your conversations here. That's just the rule of thumb, just best case scenario. Okay, I went over a lot of these requirements already. I want to go over the last bullet point because we don't typically on our agendas have a item for public comment. And you're not required to have that bullet point on your agenda, but Open Meetings Act does say if there's a member of the public that wants to make a comment, they have the right to do that. Now, typically, if there is somebody who stood up and said, hey, I just want to make a general comment, what I would say as a meeting facilitator, or what I think the chairman should say is, well, does it relate to one of the cases that are up tonight? If so, would you mind waiting for that case to raise your point? If it has nothing to do with the case, then I would reserve it for the end of the meeting, let the applicants get their cases heard, and then they can make a public comment. We actually I don't know that we've had that happen once, but I just want you to be aware of that. The Open Meetings Act has training. I think OSHA has reviewed that with you.
I just got one today.
Or Maura has reviewed that with you. It's just an online training that you take, and it's useful. It's good. It goes over all the requirements of the Open Meetings Act.
Is this a different one than the one we did?
No, that's
No.
exactly the same. Yeah. I think there are a couple members that haven't completed yet, so I may be sending out emails. I'll have to double check my list, but there's a link, you just go to the website and it's online based and you can get the training done.
So that's all the slides I have, but I do want to just open it up if you have any follow-up questions. I know it was comprehensive, it's a lot to take in.
I have one question.
Yeah.
Can the attorney override any one of our codes?
No.
Okay.
Emphatically, no. The attorney can't vote. The attorney can't override a vote. The attorney can only give you advice and legal recommendations. The attorney does not say whether a particular request is good policy or bad policy. That's up to you. You are the residents. You know, I live in Wheaton, so I'll reserve my comments for Wheaton, but I do have to give you advice. So if for whatever reason something isn't allowed in our code, my job is to tell you that. Or if it's allowed in your code, my job is to say, well, it's allowed. That's my job, okay? And I cannot do anything voting-wise whatsoever. Okay. Anything else? All right. Was there anything, did you have a staff report?
We don't, the only thing I wanted to mention, our consultant is working, on the rewrite of our zoning ordinance. There's a couple pieces that have been sort of completed in draft format. There is a steering committee that they're working with, so there's probably gonna be a while. But we may actually have, something to present next month in terms of sort of the first component of the amendments, but, it's a moving target at this point, so as of right now, we are anticipating a meeting. So the next date will be October 19th, but I'll be in contact a little bit closer to the date, just to confirm.
Go,
And,
Chef.
the last thing I'll say is, if you have, once you get that memo, if you have any questions on Gosha's staff memo, I just so strongly encourage you to reach out to her before the meeting. Because there could be a lot of things you could get cleared up that you're confused about prior to the meeting, so that the meeting clips along. And I'm gonna tell you, Gosha, whenever I call, she is so accessible, and she will get back to you immediately. So she is an excellent resource. I strongly encourage you that any confusion that you have, call before the meeting. You can't, that is one communication you can't have. That is not ex parte. That is this is your resource right here. Okay. All right.
I have a question, yes.
Yeah.
Gosha, are we going anywhere with the signs we've been trying to rework for 2 years now?
And I'm sorry,
Political
signs for?
signs? Political signs?
Political signs. So because we are so focused on chapter 17 right now, signs are in chapter 13, so that's sort of part of it. We do want to touch upon it, but we're focusing on the zoning ordinance at the time. So I still have your comment, and I know obviously
I
it's
understand, but
gonna-
it's been 2 years. I mean, do we have an idea how long it's gonna take to get there? Is it 4 years down the road, or?
in terms of the chapter 17, the zoning?
to-
No, so the plan was to have everything done early next spring, early summer, so late spring, late summer. Obviously with COVID, things have shifted a little bit, because we're not able to have these in-person steering committee meetings, and that's where a lot of that stakeholder comment, public input comes in. So we only had one of those meetings last year, or maybe it was beginning of this year. So that's why we're hoping for another one in the next few months or so, maybe by October. So it's taking a little bit longer, so because of that, I don't have that end date yet. But by next year, the chapter 17 will be completed.
Okay.
Maybe it's not gonna be the early summer that we were hoping for, but somewhere along that.
All right, anything else before I call it? Okay, do we have a motion to adjourn?
So moved. Second.
All right. Motion second, all in favor, say yes.
Yes.
All opposed, say no. All right, we stand adjourned.
Thank you.